Good afternoon, sir. Can you see and hear us?
Yes, thank you.
Good afternoon, Mr. Jenkins.
Good afternoon.
We were dealing with the theme of the capacity in which you gave evidence in criminal proceedings and your understanding of the capacity in which you were giving evidence.
Yes.
Can we continue that theme, please?
Okay.
By looking at FUJ 0015 2872. And if we look at the top half of the page, please, we'll see that this is an email from you to Penny Thomas of the 19th of December 2009 with an attachment which in fact follows this document. And you say, Penny, I attach the expert witness statement with my comments. And what you do essentially is attach Charles McLachen's second report in the Seema Misra case with your comments on it. In that first line of the email, you say, I attach the expert witness statement with my comments. You understood that Mr. McLachen was an expert witness?
Yes.
Did you understand that you were giving evidence in an equivalent capacity?
Not in the terms I now understand the capacity to be.
We're going to see in a moment that you prepared documents in answer to his and you engaged in a joint discussion with him.
Yes.
Did you understand you were performing a different function than he was?
I was clearly in a different, at least I certainly felt I was in a different position because I was not independent in the same way that he was, in that I was an employee of Fujitsu and therefore was effectively part of the Pole prosecution team.
Did you think you were part of the Pole prosecution team?
Yeah, I think I probably did, because that's how the Pole lawyers were treating me.
If we scroll forwards, please, to the report, which starts at page 4. You'll see it, his second report. And then if we go over the page, please, to page 5, you'll see there's an index. And just note for the moment, we're going to come back to it in a moment, section 5 is my duties to the court. If we go over to page 6, please. You'll see that he sets out to start with his instructions. Can you see that?
Yes, I can.
And if we keep scrolling through this, if we just do it at quite a slow pace, you'll see that he sets out his qualifications.
Yes.
And if we scroll on, please. And keep scrolling. These are all qualifications and experience. Keep scrolling. And keep scrolling. And keep scrolling. And keep scrolling. And keep going. And keep going. And again. And then at 1.3, he sets out the confidentiality of the document. And he makes some caveats. That's paragraph 1.4. This report shouldn't be read as expressing any opinion on factual matters which depend on disputed testimony of the witnesses of fact or legal issues. It reflects my understanding of the petition, then over the page. He then sets out at paragraph 1.5 his sources of information. And scroll on, please. A big list of the documents that he's been given. And then over the page. And keep going. He then sets out at point 6 of his introductory paragraphs the scope of his work. He describes himself as an expert witness, not as a witness of fact. He then sets out what he's done, looks at the documents that have been provided to him, what he hasn't done in 1.2, what he hasn't had access to in 1.3, where he attended in 1.4 and 1.5, and then scroll down over the page. And then at 1.7, he says, I've prepared an independent and objective report addressed to the court. He sets out what his company's fees are dependent on or not dependent on, and then he describes the structure of his report. And then if we can go to paragraph 35, please. Sorry, page 35. He sets out his duties to the court. He understands his overriding duty is to the court and that he has complied with that duty and will continue to do so. Then if you just scan to yourself what he says in paragraphs 2, 3, 4, 5 and 6. And scroll on. These are very similar to those things in the letter of the 18th of November 2005, aren't they?
Yes, I agree.
And then over the page, please. The expert declaration continues. Now, all of those parts that I've shown you, you would have read.
I would probably have skimmed through them, yes.
Well, you would have read them.
I would have read them, yes.
When you read them, did you think, hold on, I'm giving evidence about the very same matters that Mr. McLachlan is giving evidence. I don't say any of these things in my witness statements or documents.
No, because I thought I was in a different position, because I thought I was actually, well, for a start, I was providing witness statements, not an independent report. And so I didn't think I was, and I wasn't independent like he was.
Never mind the independence point. What about all of the things that he said as to all of his qualifications, his experience, his instructions, the documents that he had been shown, the scope of his report, the caveats within it?
Yeah.
Did you think, well, hold on, I've done none of that?
I probably realised I hadn't done any of that, but I didn't see that. What I did was what I was asked to do, which was provide a witness statement, or at this stage, all I was doing was providing comments on his report.
When you read this and you thought, I've given witness statements in the past, in the capacity as somebody with expertise about Horizon, I've not included any of these things in any of the documents I've produced. Should I have done so?
That didn't occur to me at the time. Maybe it should have done, but it didn't.
You said a moment ago that you thought that you were appearing or performing a function in a different capacity. Did that actually occur to you at the time, i.e. you addressed your mind to the fact that you were a witness from Fujitsu, therefore lacked independence, and therefore the nature of the documents that you produced fell to be differently constructed?
I'm not sure that I'd actually analysed it that far. I was basically doing what I'd been asked to do, which was comment on the report, and it was then suggested that it was presented in terms of a witness statement, so that's what I did.
Can we go forwards, please, to poll 302-9411? This is one of Mr. McLachlan's reports. It's 50 pages long with very lengthy exhibits to it. Again, in the Seema Misra case, this one's dated the 4th of October 2010, you were provided with this report, weren't you?
Yes.
And did you read all of it?
I didn't necessarily read the introductory bits of it. I was more concerned with the technical information that was in there and commenting on that. I may have read the whole lot, I can't remember now. But what I was really interested in was the technical information in the report rather than things like the expert declaration and things like that, because I didn't see that that was particularly relevant to what I was being asked to do at the time.
And again, do you now remember that you skipped over or were not interested in the parts of the document that set out an expert's duties?
I can't
and
remember.
The like?
Sorry, I can't remember exactly what I did at the time, but as I say, what I would have been interested in and what I knew that I was being asked to address was the technical aspects of the report.
By this time, this is October 2010, so shortly before the trial commenced, you were aware that this was a criminal prosecution of Seema Misra,
Yes.
a serious matter.
Oh, yes.
And were you conscious of the seriousness of the matters, certainly for her, by this stage?
Yes, I suppose I was.
And you would therefore presumably have wished to have approached your duties conscientiously and with care.
Oh, yes.
Can we look, please, if we go over the page? Again, the index page, and then over the page, please. And again, there's an introduction, and if we go over the page, and again, he sets out a summary of findings. If we go to page 20, please. Read this together. Section 4 of his report is points of difference between him and you. And he says, I submitted my draft report to Gareth Jenkins, the expert from Fujitsu, instructed by the Post Office for his review on the 1st of October 2010. And that's right, isn't it? He sent you a draft of his report.
Yes.
We then had an opportunity to discuss points of fact and opinion over the phone. Jenkins was able to advise me of some errors of fact based on his extensive understanding of the Horizon system, which I've not sought to dispute, and I've incorporated corrections arising from these errors in this final report. Jenkins also indicated some areas where he held a different opinion, and this section seeks to set out explicitly where our opinions differ side by side. I'm relying on his annotations to my draft report faithfully to represent his position for the convenience of the court. I apologise if any of the individual items I've inadvertently misrepresented him or omitted comments of importance. And then 4.2, in relation to 2.2.1 transaction corrections, Jenkins is of the view that because the sub-postmaster accepts the transaction corrections has an opportunity to raise issues for correction, this is not relevant to the case. In my view, if transaction corrections are incorrect or omitted, then it is necessary for the sub-postmaster to be able to have the evidence and training to contest them. The fact that there is a process for transaction corrections mean that data entry errors are recognised as occurring. The system does not automatically provide the evidence in the form of vouchers to enable the sub-postmaster to easily raise or contest transaction corrections, nor have the Post Office provided evidence that demonstrates that the training of Misra equipped her to deal with transaction corrections effectively. And then another example, if we go over the page, please. In relation to 2.2.1, Jenkins is of the view that because sub-postmaster accepts the remittances and has an opportunity to raise issues for correction, this is not relevant to the case. In my view, there's testimony from other sub-postmasters that the end-to-end remittance process introduces incorrect data into Horizon. Because I've had no opportunity to investigate this, I'm unable to exclude this as a source of problems at West Byfleet. So you engaged in a discussion with him
Yes.
And he provided this document which sets out his views and yours where they differ.
Yes.
And you would have read this.
Yes, I would have done.
Again, did you not think that you were giving evidence in the same capacity as Mr. McLachlan?
Well, I didn't see it in quite the same way because, again, I was there as an employee of Fujitsu and therefore very much as part of the Horizon system, whilst he was there as a totally independent person. So I didn't see it as being quite the same.
You were being treated as the expert from Fujitsu that had been instructed by the post office, as he says in his report.
Yes, okay.
Can we go to page 27, please? He sets out the terms of reference for this exercise.
Yes.
And he sets out his instructions in point 1, point 2, his qualifications. And it follows the same format as the previous report. I'm not going to take your word.
Yeah.
You would have read this, wouldn't you?
Yes, I probably would have skimmed through that because I didn't think that was particularly relevant to the technical things I was being asked to comment on, but I probably would have read through it.
Did you not understand that you were the subject of the same duties as is set out over pages and pages in Mr. McLachlan's report?
No, I'd not understood that.
Did you ask anyone, am I subject to the same duties as that this other man keeps writing pages and pages about in his reports?
No, I didn't ask anyone. Perhaps I should have done, but I didn't.
Can we move on, please? FUJ 0015 6248. It's an email of the 1st of October. That's the date that, if you remember, that Mr. McLachlan said that he had sent you his report.
Yes.
From you to Jarnell Singh, Penny Thomas, and then Jean-Philippe, who I think you mentioned earlier, Jean-Philippe Prenevost. Who was Mr. Prenevost?
He was a lawyer within Fujitsu.
You say, and Tom Lillywhite. Who was Tom Lillywhite?
He was Penny's boss.
Thank you.
And head of security at that time. So effectively the role that Brian Pinder had earlier.
You say, Jarnell, third paragraph, as discussed, this is what I've received from Charles McLachlan, the defence expert in the West Byfleet case. I'm concerned about the tone and some of the things being attributed to me. I'm in the process of annotating the document with my thoughts and comments. Charles, that's Mr. McLachlan, spoke to me earlier this morning and has arranged to discuss my views with me at 4 p.m. this afternoon. At this point, I'm reluctant to have that conversation without some further guidance. When I get to the end of the document, I'm happy to pass on my annotated copy. And then something else. So you were asking Mr. Singh, is that right, for guidance on Mr. McLachlan's report when you first saw it, and you got, in fact, 14 pages into it?
Yes.
Is that right?
Yes.
And it goes to the lawyer at the post office, Mr. Singh, and to Fujitsu Legal,
Yes.
Mr. Prenevost, is that right?
Yes.
And was this a plea by you for some guidance before your planned call with Mr. McLachlan later that day?
Yes, clearly, yes.
You say you were reluctant to have the conversation without guidance, further guidance.
Yes.
What guidance were you looking for? Guidance about what?
what I should be saying, how I should conduct the conversation and so on. And I can't remember what guidance, if any, I did actually receive, but I think I did have the call with Charles McLaughlin later on that afternoon.
Can I press you on what guidance you were looking for?
How I should approach things. So it was really a case of, I thought there were things in that document that we'd already discussed before, and I thought we'd agreed that they weren't relevant, and here they were coming back up again. So it was a case of, why is that happening?
So was it about the substance of what Mr. McLachlan was saying in the report?
Yes.
Rather than your role, the role that you were performing, that
No.
you were seeking guidance?
No, it's the substance.
How could they each help you, the two lawyers, on the substance of what he was saying?
It was really a case of, why was he coming back with things that I thought we'd already discussed, and what I should do about that, and how to approach that in terms of discussing things with him, as far as I can remember.
You tell us in your third witness statement, paragraph 463, that Mr. Singh did not reply to this email. Okay?
Okay. I can't remember the detail at this point, but I clearly had researched at the time I was writing that witness statement.
Can you recall whether any guidance was forthcoming from anyone else, including Mr. Prenavos at Fujitsu?
I can't remember. I don't believe I've seen any emails that suggest that. Whether there were any phone calls or not, I just can't remember.
By the time you were sending this, you hadn't finished reading. You were a third of the way in.
Yes, I mean, the point was I'd received this probably first thing in the morning, so I thought, whilst I'm reading it, then that gave people a chance to react, because I'd already established the fact that Charles McLaughlin wanted to talk to me at 4 o'clock this afternoon. Therefore, let's give people warning so they have a chance to see what they can do to help me in preparation for that call later on that day.
Did you go back to Mr. Singh or Mr. Prenavos when you'd finished reading the report?
I think at some point I sent an annotated copy of the report out. I'm not sure exactly who to, probably to the same people. I can't remember the exact sequence of the emails.
That's the one we looked at earlier, the annotated version of the report.
Yes, but I can't remember exactly who I sent it to and at what stage in the proceedings. No, I think the one that we looked at earlier was one from about 2 or 3 days later.
Okay, you think on this day you sent an annotated version out?
I believe so, but I can't be 100% sure.
Did you at any time ask anything about the duties of an expert witness, about which Mr. McLachlan spoke extensively in his report?
I doubt it. I was more concerned about the technical detail rather than things like that I saw as being administrative parts of the report.
Did you chase Mr. Prenavos to say, look, I'm still doing this without any guidance? Can I get some help, please?
I can't remember.
Or did you just plough on?
I probably just ploughed on, but I don't know.
Did you have an in-person meeting with Mr. Singh, Mr. Longman and Mr. Tapford about this?
The following week I did, yes.
I think we've got no note of that meeting. Is that right, so far as you know?
I don't remember seeing any note of that meeting. I certainly haven't seen one as part of the inquiry.
And I don't think you've got a recollection of what was discussed at that meeting?
No, my main recollection is coming up to London to have a meeting in barristers' chambers, which is something I'd never done before, and meeting, I think that was probably the first time I'd met all three of them. So, though I'd spoken to them on the phone before that, but exactly what was discussed at the meeting, I can't really remember.
So is it the case that when you were looking at the matter generally, sent these documents from from Mr. McLachlan, and you read the parts in them that concerned his instructions, the documents with which he'd been provided, the scope of the work that he had undertaken, the caveats to the work that he had undertaken, the limitations of it, and quite extensive passages about the duties of an expert, that didn't trigger anything at all with you?
No, I don't think it did.
Can we turn forwards, please, to FUJ 0012 4313? This is a document in a different case.
Yes.
This is concerning the prosecution of Kim Wiley. And it's a document prepared by you. We can see the date, the 19th of February 2013. Can you see that?
I can see that, yes.
So it's 2 and a bit years later.
Yes.
And what you do, if we just summarise what you do in this report, it comments on essentially requests for disclosure that were being made by the defence in Miss Wiley's case. And what you do is you set out passages from a report, an expert report by Michael Turner, and then you comment on them.
That seems to be what this is doing, yes.
Okay. You say in the introduction, I've been asked to comment on the document, report, disclosure requests, computer evidence provided by the defence in the case of Kim Wiley. In order to do that, I've copied in the report below in blue font and added my comments in black font. Again, I don't think we've got the
Yes,
natives.
I appreciate that.
We'll have to work our way through it. In summary, it would appear that the defence expert is looking for as much information as he can to carry out a detailed analysis. I've no problem in him doing that, and I'm happy to assist in such an analysis, as I've done in the past with other defence experts, since the data requested is proprietary to Horizon or Horizon Online and is unlikely to be understood easily without some guidance. Any such analysis is likely to require a lot of time and effort to analyse and therefore incur considerable cost and elapsed time. And then 2, disclosure requests computer evidence, terms of reference. Now this is you setting out passages from Mr. Turner's report.
Yes, this is just a cut and paste of Mr. Turner's report.
You'll see that he sets out his instructions. And then at 1.3, he sets out his qualifications. Over the page. And he annexes a CV in Appendix A. I'm not going to look at that. He sets out a statement of independence. And then underneath statement of independence, you've written, I note that the CV refers to another Horizon case, the Crown and Julia Richards, Winchester Crown Court. I've no knowledge of that case. That's you adding that in.
Yes.
And then back to him. I've made a declaration at the end of this report. And then he continues. I'm not going to go through all of this. The part that's indented is him, and the part that's not indented is you. Is that right?
That's my belief, yes.
And can we go on to page 6, please? And scroll down. Experts' declarations. You'll see that Mr. Turner had set out the expert's declaration.
Yes.
Yes? I understand my overriding duties to the court. I set out in my report what I understand from those instructing me to be the questions in respect of which my opinion is required. I've done my best to be accurate and complete. All of the matters on which I've expressed an opinion lie within my field of expertise. I've drawn to the attention of the court all matters of which I'm aware which might adversely affect my opinion. Where I've no personal knowledge, I've indicated the source of factual information. I've not included anything in my report which has been suggested to me over the page by anyone, including the lawyers, without forming my own view, independent view. Where there's a range of reasonable opinion, I've set out the extent of that range. At time of signing, I believe it to be accurate. I'll notify those instructing me if I subsequently consider that the report requires any correction or qualification. The report will be evidence that I'll give under oath. I confirm that the facts in my report are within my own knowledge, etc. And then you've added standard stuff. No comment required, haven't you?
Yes.
In this context, standard means usual or normal, doesn't it?
It means I'd seen something similar before, and for example, in the case of Mr. McLaughlin, but I hadn't really taken much notice of it, and I didn't think any of that really applied to me. Wrongly,
Is that what that means? You're saying
that I think
rather
is,
more than those 5 words set out.
that was what I think I was felt at the time, that I'd seen that sort of stuff in other reports, but I didn't see that any comment was required, and I didn't realise that it applied to me because I wasn't making such declarations.
That's not what you say here, is it?
No.
You say it's standard stuff, and standard stuff here, would you agree, in context means it's normal or usual?
What I meant by that was that I'd seen something similar to that before, for example, in Professor McLaughlin's reports.
So on your account, it indicates that it was something with which you were familiar.
I'd seen it before.
And therefore it was standard.
For independent experts' reports.
So going back to paragraph 1 of this list, you understood that his overriding duty was to the court. Yes?
Yes.
That's standard, usual stuff.
Yeah.
Did you understand that your overriding duty was to the court?
Well, I took overriding duty to the court being just to tell the truth.
So the answer is yes, you did understand that you had an overriding duty to the court.
Yes.
Paragraph 2, you were familiar with that. That was standard and usual, that the expert should set out in their report the questions in respect of which the expert's opinion was sought.
I'm not clear that I would necessarily have considered all those points in detail when I wrote standard stuff at the end. I was just commenting in general on section 4 is an expert declaration, and I'd seen expert declarations before, so I doubt if I would have gone through looking at each of those paragraphs in detail and considering what they said. It was a case of, yes, I had seen an expert declaration at the end of reports before, and I saw that as a standard thing without going into detail as to exactly what it said.
In relation to paragraph 3, which you regarded as standard or usual, did you understand that your duty in preparing documents was to be accurate and complete?
Well, yes, certainly I needed to be accurate and complete, but to say whether I took detailed note of exactly what it was saying in there at the time, I think it's unlikely. I think I just saw that as an expert declaration, and that comment was referring to that as a section rather than to the individual words within it.
When you were preparing statements or reports that were annexed to statements, did you understand that you were under a duty to mention all matters which you regarded were relevant to the opinions which you expressed?
I don't know that I did understand that, because I'm not sure that I necessarily did.
When you provided statements to the court or reports that were annexed to statements to the court, did you understand you were under a duty to draw to the attention of the court all matters which might adversely affect your opinion?
No, I didn't understand that at the time.
You thought you were entitled to keep to yourself matters that might adversely affect your opinion?
I was asked to comment on documents and reports, and that was all I thought I needed to do, and that's what I tried to do.
Answer the narrow question that was asked of you.
Yes. And no one had told me that I needed to do more than that.
Did you understand yourself to be under a duty to indicate in your documents submitted to courts where you have no personal knowledge of a matter mentioned?
No, I wasn't aware that I had any need to do that.
You weren't aware that you had to indicate the source of your information if it wasn't direct knowledge?
No.
did you think, looking at number 6, that you were permitted to include matters in your documents submitted to the court, if we go over the page, which have been suggested to you by anyone else, including the lawyers?
No, because certainly, as we've seen in some of the cases, then there were comments made on my reports by the lawyers, and I actually changed things there as a result of some of those comments. So therefore, I didn't realise that there was anything wrong with doing that. Obviously, if I disagreed with the comments, then I would not change things. But if I was happy to agree with the comments and that it didn't detract from what I was trying to say, then I was happy to accept suggestions as how my wording could be improved.
We're going to come tomorrow to look at, in some detail, at the occasions when you changed your evidence as a result of the suggestions made to you by others,
yes,
in particular lawyers.
Yeah.
You didn't understand that you were under a duty not to include in your documents suggestions made to you by others.
No, I didn't understand that at the time.
Did you understand that you were under a duty to set out a range of expert opinion in relation to a matter where there was a range of expert opinion?
No, I'm not sure that necessarily applied, but no, it certainly wasn't that clear. I wasn't aware of that duty.
Why do you say you're not sure that that necessarily applied?
Well, they talk about a range of opinion, then I'm not sure that there were cases where there was a range of opinion.
On all the matters that you gave evidence, the question,
okay,
the answers were binary.
Well, okay. I certainly wasn't aware that I needed to set out anything to do with the range.
And in relation to the other matters mentioned in paragraphs 8, 9 and 10, are your answers the same, that you wouldn't be familiar with those duties as applying to you?
No, all I thought I had to do was answer the questions that I was being asked to answer, and that they had, obviously the answers had to be truthful.
Now, none of these obligations can have been new to you, because you wouldn't have described them as standard stuff, would you?
They weren't new to me, but I don't think I'd taken in the detail of them at all. I just, as I said earlier, that the standard stuff was probably more to do with the title of the section, expert declaration, rather than the details of the 10 individual points within that. You
weren't saying the title is standard stuff. You're saying the content.
The content is
standard, aren't you?
Yes. But I hadn't really considered in detail what the content actually was saying.
Why not?
Because I was concerned with the technicalities. So it was the other bit. I'm a technician, so I was more concerned about the facts of how the system was working rather than the legal niceties, if you like.
Well, both Messrs. McLachlan and Turner were technical experts too, weren't they?
Yes.
Did you think, well, hold on, I keep reading these reports from other guys, and they keep saying this stuff at the beginning and the end of their reports about the duties that they're under. Does any of that apply to me?
Well, I wasn't producing reports, I was producing a witness statement.
And do you think that is the answer to the question? Because the document on which you were typing, or was being typed for you, is headed up witness statement, you needn't have abided by any of these requirements?
It didn't occur to me that this would apply to me. I clearly understand now that that's wrong, but I mean, that was where I was at the time.
That can come down, thank you. You tell us in your third witness statement, no need to turn it up, it's paragraph 331 at page 110, quote, I knew that like any other witness, I was required to be truthful, although it would never have occurred to me to be anything else. The approach that I took was the one that was asked to take by post office lawyers. David Jones, a lawyer at Fujitsu, also read at least some of my witness statements. You deal at length at that witness statement with the limited instructions you say you were given and your limited understanding of an expert's duties. You were, however, aware that you were being asked to produce technical evidence on which a criminal prosecution was based, weren't you?
Yes.
You would have been aware that the outcome for the sub-postmaster in question, the outcome that the post office was seeking, was the criminal conviction of a sub-postmaster.
Yes.
You'd be aware of all of the consequences that such a conviction would entail, including a possible term of imprisonment.
Yes.
You signed a statement of truth on each of your witness statements, didn't you? A declaration.
Yes.
I think you acknowledge, or we'll find tomorrow that you acknowledge, that the witness statements that you signed presented a partial picture of what you understood about Horizon's issues and faults, because you were answering only the narrow questions that you had been asked.
That's correct, yes.
How did you feel able to sign witness statements with a declaration on them which presented only a partial picture of what you understood about Horizon's issues and faults?
I don't think I was being asked about Horizon's issues and faults. What I was being asked to do was address the questions in the reports that I was addressing.
You would know that witnesses, when they come to give evidence, are asked to tell the truth and the whole truth.
Yes.
Did you think you were only required to tell the truth in your witness statements?
I was talking about those aspects that were related to the Horizon system, and I believe I did tell the truth and the whole truth as far as the Horizon system was operating in the specific branches at the specific times that I looked at data.
But you didn't feel under any compunction to volunteer information about other faults or system defects about which you had not been asked?
I didn't think that they were relevant in those particular cases.
And just expand on that. You're saying that you took a conscious decision not to mention them because of your own assessment of relevance.
Not a conscious decision. As far as I was concerned, the system was behaving correctly in the branch at the time, and I'd seen nothing to show that it wasn't. And therefore, other issues that I may have been aware of were ones that had gone on in the past or in the future and had been fixed and did not apply to the branch at the time that I was considering.
We'll come to the detail tomorrow, but in the light of the answers you've just given, are you saying that in every case in which you provided a witness statement, you had undertaken or caused to be undertaken a detailed examination of the data relating to that branch?
I'd undertaken an analysis of the data, not necessarily a completely thorough analysis of it, but I thought what I felt at the time, it was sufficient to show that things were working okay at that time.
What about the generic witness statements that you supplied later?
Those, I think, were done at a much higher level. They were giving they were effectively saying that Horizon was behaving as it should, and that information could be found from the audit trail to show what had actually happened in the branch to look at any more detailed question.
Can we look, please, at your third witness statement at page 139? And again, we're going to deal with Ms. Misra's case in detail tomorrow and on Thursday. But can we look at paragraph 404, please? You're dealing here with Ms. Misra's case, and you say, I've already explained that I had referred to the event timeout and locking issues causing missing transactions in Legacy Horizon, and that Fujitsu had drawn these to Mr. Singh's attention. I don't believe that the post office asked me whether it should disclose these or any other Horizon problems to Mrs. Misra. I haven't seen any emails around this time which suggest that. I hadn't been involved in responding to defence requests for disclosure in 2009, nor the abusive process application made by the defence in February 2010. I don't think my email about of the 1st of March 2010 is about disclosure at all. So you say here that you can't recall the post office ever raising whether they, the post office, or you should disclose the issue of locking problems to Miss Misra.
Correct.
By this time, you knew that if you were to sign a witness statement in Miss Misra's case, you would have to sign a statement of truth on it.
Yes.
And you knew that those statements were being used as evidence in court to support a criminal prosecution.
I had sought guidance. I'd said that until we had actually looked at the data, that I was not able to say that there weren't any problems in Horizon. And when I came to get to see the data, which was in early March, then there was a check done of the NT events, which was the way that this event timeout problem manifested itself, and therefore I was able to exclude that as having been a problem in that branch.
By this time, you had got, this is 2010, wider knowledge of bugs, errors and defects in the Horizon system than in the event was reflected in your witness statements in the SEMA Misra prosecution.
I'm not quite sure what you mean by that.
So by March onwards, March 2010 onwards, when you made witness statements in SEMA Misra's case,
Yes.
you didn't disclose in those witness statements all bugs, errors and defects with about Horizon of which you knew.
I didn't think I needed to do that because of what I thought I needed to worry about were ones that had actually occurred in that particular branch at the time in question.
Did you consider reflecting in your witness statements or making qualifications in your witness statements to set out exactly what you had been asked to do and not asked to do, and make clear that you had not been asked about other issues?
That didn't occur to me, I'm afraid.
Looking back now, do you think that a reader of your witness statements could reasonably gain the view that you were setting out all that you knew about bugs, errors and defects in Horizon?
I don't think I was ever asked to consider bugs, errors and defects. What I was asked to do was comment on the reports produced by Professor McLaughlin.
We've seen you on a number of occasions provide information through an informal channel, through emails, to Post Office.
Yes.
Did you have any understanding or expectation of whether that information provided informally would be disclosed to the defence in the criminal prosecutions you were involved in?
I didn't know I didn't understand how the process worked in that respect. I mean, clearly, if someone had come back to me and said, well, in that case, you need to put something about it in your witness statement, I would have done that, but no one did.
Did you think to include in your witness statements the fact of your informal communications with both Post Office and Fujitsu about the substance of the evidence that you were to give?
No, that never occurred to me.
Or the detail of those communications?
No, I didn't think that was relevant.
What did you think was going to happen to the information in those communications?
I didn't know what was going to happen to them. As I say, if someone had told me that I needed to do something about it, I would have done something about it, but no one came back and said I needed to do anything formal about that sort of exchange.
That document can come down, thank you. By the end of the SEMA Misra trial, would you agree that you have by then had a number of opportunities to see whether the Post Office was adopting an approach of seeking to tweak your evidence for its own interests?
I didn't think that at the time. Having looked back at things now, then I can understand that that may have been happening. But at the time, I thought everything that was happening was just a legitimate tidying up of the statements to make them more readable.
Are you really saying, bearing in mind we're going to look at these tomorrow, that you thought that what happened in both the Huey Thomas case and the SEMA Misra case was a tidying up exercise to make your statements more readable?
And clarified, I don't think any of the changes that were made actually changed the technical background to what was happening. Yes, it changed the wording and the way that things were explained to some extent, but I think in terms of they were still setting out the facts as I understood them at the time.
I'm thinking more about the things that the Post Office was trying to get you to include. And by the time we got to October 2010, had you not formed the view that the Post Office had tried to alter the substance of your evidence, both in the Huey Thomas case and in the Seema Misra case? And in some cases you'd resisted and sometimes you'd not.
I'd not seen it that way. I mean, looking back at it now, I can understand exactly what you're saying, but at the time I didn't see it as being anything strange or unusual.
Can we look, please, at your witness statement, your third witness statement at paragraph 466, please? Which is on page 162. Scroll down, please. Thank you. 466. Thank you. We're going to come back again to the detail of this later. But you say on that time and date, you emailed a draft statement to Mr. Tatford, Mr. Singh and Mr. Longman. This is in Seema Misra's case.
Yep.
I use the same template as I have for all my previous statements. I specifically asked for their feedback as to whether it was correct in terms of approach and style. No one suggested I needed to add any sort of expert declaration to it. Mr. Tatford made comments on the draft which are visible at, and then you give a reference. He appeared to want me to make some points more strongly in favour of the Post Office than I had done. In particular, he wanted me to say it looked as though Mrs. Misra had stolen the money rather than it was incompetence. And then if we go forward to paragraph 468, which is over the page, you say, I think overall my responses to Mr. Tatford's comments demonstrate that I was not comfortable with some of the points that he tried to press. So by this time, you had had the experience of Graham Ward in the Huey Thomas case seeking to press amendments to your witness statement, hadn't you? Back in 2005.
Yeah, I mean, yeah, I was going to say that's about 4 or 5 years earlier, so I probably wasn't really conscious of that at this time.
Had you not remembered? I mean, you didn't make witness statements in many cases. I think it's 15 overall.
Yeah.
Had you not remembered Mr. Ward being dissatisfied with your use of language in a witness statement and making a marked up version for you, suggesting parts being deleted?
I probably didn't remember that in 2010, no.
But in any event, here you say that Mr. Tatford wanted you essentially to harden up the case against Mrs. Misra.
I'm saying that now looking back at the email exchanges. I wouldn't necessarily have put it in that terms back in 2010.
Why not? A barrister saying, please include in your witness statement, if we just go back to what you said at the foot of the page. 466, in particular, he wanted me to say it looked as though Mrs. Misra had stolen the money rather than it was incompetence.
Yeah.
It doesn't take hindsight to realise that's a barrister asking you to harden up the case.
Well, yes,
the defendant,
and I refuse to do so.
Yes.
I'm asking about how,
I'm so sorry. I'm asking what effect this had upon you.
I don't know. I just assumed that this was normal practice. I had no experience to compare it with.
Did it not make you feel uncomfortable?
Yes, it probably did make me feel uncomfortable, which is why I resisted it.
Why did it make you feel uncomfortable?
Because he was trying to change what I was saying to say what he wanted to say rather than what I wanted to say.
Did this not cause you to think that there is a need for caution here in my dealings with the Post Office, in particular when giving evidence on behalf of the Post Office, that their barrister is trying to get me to say something that I can't and don't want to say?
No, I think it just made me make sure that I did stick with my guns when I disagreed with what I was being asked to do.
Again, did you not consider whether you ought expressly to qualify your statements to spell out what you were saying about Horizon not being your complete knowledge of about Horizon integrity?
That didn't occur to me at the time.
As I've said, you later went on to produce so-called generic statements.
Yes.
In a series of cases, essentially without access to the complete underlying data.
Yes, because I saw those as being high-level statements. I was expecting to get into more detail at some later stage. As I say, when I first produced that, I had no knowledge as to anything that was involved, and I assumed that that was normal practice. I now understand that it wasn't and was probably totally inappropriate, but at the time I didn't realise that.
Did your experience in the Huey Thomas case and the Seema Misra case, and the approach of the Post Office in particular in the Seema Misra case, not suggest to you that you ought to proceed with extreme caution in producing such generic statements?
I didn't realise at the time that anything was actually improper or going wrong with what was happening. I did get, certainly in some of the cases, with the generic statement, I did actually seek guidance from Fujitsu lawyers as well as Post Office lawyers as to whether this was the right thing to do and whether I should carry on making those sort of statements, and they seemed to be supporting what I was doing.
Or was it the seeming success of the approach in the Misra case created a false sense of confidence for you and for the Post Office? It resulted in a conviction after all.
I don't know that I considered it that way. Again, the generic statement was about 2 years later, so I was probably looking at that in isolation rather than looking back as to what had happened before.
Can we just look back, please, to your attitude to witness evidence in a different case by looking at FUJ 308 3741? And if we just scroll down, please. Can you see that the email from Mr. Dunks to you and Penny Thomas of the 28th of October 2010 concerns Porters Avenue, which I think is Mr. Hosey's branch, yes?
Yes, I believe so.
It looks as if everything has been sent at one time or the other. I can send all if wanted, etc. And then I just want to see your reply. If we scroll up. You say, Andy, can you let me have them all? I've got to do another, quote, expert report. And this time, I want to actually read your logs properly. You're writing here to Mr. Dunks and Penny Thomas, yes?
Yes.
Well-known colleagues.
Yes.
And you're purposely using the term expert report by putting it in inverted commas, aren't you?
Yes.
Was that what had been requested of you?
I can't remember exactly what had been requested of me at that time.
But you're putting it in inverted commas like it's a term of art, yes?
I can't remember. I tended to be fairly liberal with the inverted commas and capital letters and things like that in my emails.
Isn't this an indication that you realised that what you were being asked to do was not simply give evidence because you had expertise in an area, namely the Horizon system, but you were being asked to provide an expert report, just like the ones we've read?
No, I don't think so. I think it was more to do with the fact that it was a report as an expert on Horizon, someone who actually understood the Horizon system well.
Your evidence is that although you'll say here that you've got to do another, quote, expert report in inverted commas, you didn't understand what that meant, i.e. the provision of an expert report, or that it came with specific duties.
That's correct.
By this time, you produced statements for use in Huey Thomas's case and earlier in the year in Seema Misra's case.
Correct.
you say here, this time I want to actually read your logs properly. Had you not considered the logs properly in those other cases?
I don't know. I certainly had not read been shown any logs to do with Mr. Thomas's case. I was aware in Mrs. Misra's case that there were some logs which I thought had been handled by Andy Dunks, and when I listened to his evidence in court, I realised that there were some things that he was saying that maybe I should have looked into, and I actually did some investigation that evening as to what I'd heard about the logs, and I realised that actually maybe in future I should have actually taken more notice of what the help desk calls were involved, hence this comment here.
It was a flippant comment, wasn't it?
I don't know, it was a flip comment. It was more a case of saying I had learnt from the fact that I'd been taken by surprise by some of the things that Andy was saying in Mrs. Misra's case as to what he'd actually found in the help desk calls that I'd not been aware of, and realised that maybe I should have taken more notice of those, and therefore, moving forward, I wanted to learn from that.
Thank you. So can we break until 3:15, the afternoon break? Thank you very much, sir. Good afternoon, sir. Can you continue to see and hear us?
Yes, thank you.
Thank you. Mr. Jenkins, you told us today that you were never provided with written instructions as to the duties and responsibilities of an expert witness in the cases in which you were instructed.
Correct.
And that you've no recollection of anyone explaining to you that you were subject to certain duties as an expert, or being given oral instructions as to what those duties were.
Correct.
Have you read the witness statement of Warwick Tatford, the prosecution barrister in the Seema Misra case?
I have.
And did you listen to or watch his evidence or read the transcript?
I was actually here for that particular
that day. Can we look at his witness statement to start with, please? WITN 0961 0100. And page 5, please. Second line down, at the time of the Misra case, I ensured that the calendar square bug was disclosed and made it very clear to those instructing me that inquiry should be made with Fujitsu about any other problems and any other bugs that should be disclosed. I made this clear also to Gareth Jenkins, the expert instructed by the Crown, and I made it very clear to Mr. Jenkins that he was under a duty to provide frank disclosure of Horizon problems to the defence expert in that case.
I don't believe that we had that sort of conversation. Also, I believe that Mr. Tatford sent that information to one of the post office investigators, who then asked me a slightly different question rather than the full question that Mr. Tatford had intended for me to be asked.
That's certainly the case, because we can see that on the document. We'll explore those tomorrow, as we've explored with other witnesses.
But I've no recollection of being asked to talk about other bugs or that I would have considered irrelevant anyway by Mr. Tatford or anyone else.
So I want to get your evidence clear on this. He says that he made this clear, i.e. that any other problems or any other bugs should be disclosed to you, and that he made it very clear to you that you were under a duty to provide frank disclosure of Horizon problems to the defence expert. Are you saying that he is incorrect?
I'm saying that I had not understood that from him.
Did you have a conversation with him about the extent to which you needed to provide disclosure of Horizon problems to the defence expert?
I have no recollection of such a discussion.
By that, do you mean it did not occur or that it may have occurred, but because of the passage of time, you no longer
I
remember?
don't believe it would have occurred, because if it had, I would have done something about it.
You appreciate there's a bit of reverse
Yeah.
engineering going on there.
Yeah, I understand that, yes. But as I say, I have no recollection of it, and if I'd been told I needed to disclose other problems in Horizon, then I would have made efforts to find out about other problems in Horizon, even though I thought that they would have been irrelevant.
Well, hold on. A moment ago, you said that I wouldn't have told the defence expert about problems in Horizon because you wouldn't have believed that they were relevant to Seema Misra's case.
Well, that's right. So therefore, if I'd been told explicitly I should have done, then I would have done something about it. But that's why I'm saying that I would not. I don't believe that I was told that I needed to do that.
So his evidence here is in error, is it?
I can't say categorically that. I do, that is not my understanding of what occurred at the time, and I think I would have behaved differently if I had been briefed in the way that he suggests that he briefed me.
What do you remember about a conversation with Mr. Tapford about the extent of your disclosure duties to the defence expert?
I don't remember having any conversation along those lines.
Can we turn to INQ 401094? And turn to page 17, please. And if we look at internal page 68, which is bottom right, line 3 onwards, this is Mr. Tapford giving evidence. You say in your statement, I'm not going to turn it up, you took great pains in all your conversations with Mr. Jenkins to make sure he understood the duties of an expert witness. Yes. You explained it was his overriding duty to assist that should be court. Yes. To give an opinion that was objective and unbiased, and that duty overrode any obligation that he might feel to the party calling him, the post office. You explained that it was his duty to disclose anything that might undermine his position, and that he should be entirely open with both the post office as prosecutor and Professor McLaughlin about any Horizon problems. Him. Oh, yes. Because I had asked previously in my advice for Fujitsu to be contacted and to inform us of any problems. And I saw Mr. Jenkins as an obvious route to doing that. That's how I saw things. And it seemed to me, particularly over the page, from the feedback I was getting from the defence, that this approach was working. You refer to the defence. Are you saying that was a conversation with a colleague in chambers? He says no. Then answer, it was perfectly clear to me that he found it helpful to work with Mr. Jenkins. It seemed to fit his way of doing things, because his way of approaching things was to suggest hypotheses which needed someone to help him with. They needed to sit down, and it's absolutely clear that they did from the evidence that they both gave at trial. Before we get into the detail of the communications, if you were mindful of these expert duties and the need to make them crystal clear in somebody who did not enjoy functional independence from the party that was calling them, and you explained them to Mr. Jenkins, how is it that every witness statement which the post office sought to rely on from Mr. Jenkins omitted any of the necessary inclusions from an expert report? And he answers, because most of, until the last statement, all of those were responses to Professor McLaughlin. It's important to bear in mind that there had been an abusive process, etc. Did Mr. Tapford make clear to you the duties that he spoke about?
I don't believe he did.
If we just go back to the previous page, bottom right. Duty to give an opinion that was objective and unbiased. Did he tell you that you had a duty to do that?
I don't believe so.
Did he tell you that that duty overrode any obligation that you might feel to the party calling you, the post office?
I don't believe so.
Did he explain to you that it was your duty to disclose anything that might undermine your position?
No, I don't believe so.
He explain to you that you should be entirely open with the Post Office and the defence expert about any Horizon problems?
I don't believe so.
That can come down, thank you. Had you been made aware of your role, your formal role, as a prosecution expert witness in the legal sense, in respect of each of the Post Office's criminal prosecutions and the legal duties that that role entailed, how would you have sought to have done things differently?
Well, I think it would have required an awful lot more effort than was actually put into the various cases. The best example I can think of is that there was a whole team of us who did quite a lot of analysis of previous bugs as part of the GLO proceedings in 2018, and it would have required something of a similar sort of degree of effort to do that if it had been understood that that was what was required at the time.
Did that occur to you at the time, that we're putting all of this effort and money into defending the Post Office in a civil claim for damages? We didn't do this when we were prosecuting dozens of sub-postmasters.
No, that didn't occur to me at that time, no.
Quite striking, isn't it?
Looking back at it now, I can understand that, but as I say, that was not something that occurred to me at the time. As I say, in all cases, I was responding to specific requests to do specific bits of work, and I was being asked to do a lot more work in 2018 than I had been in previous cases.
In your witness statement, it's your third witness statement in paragraph 17, no need to turn it up, you say that you approached the various criminal cases where you provided evidence in the same way as you approached a problem in the day-to-day course of your work.
Yes.
That's something you said in summary today as well.
Yeah.
And that you focused on the question of what the data in a given case might show about the specific branch,
yes,
rather than any other wider problems with Horizon.
Yes.
And you also say that you didn't understand that other issues within the Horizon system, including issues that had affected other branches, might be regarded as important by a court.
Correct.
And you say that's all in the context that it's inevitable that a system like Horizon would have bugs, errors and defects in it.
Correct.
Are you saying that in determining what had caused the particular issue at a branch, you would only consider the data that you had been specifically provided with?
Including the information we were given about what was happening at the time, but yes, that was basically what we'd look at.
Would that data have been provided to you by the Post Office or by Fujitsu?
Fujitsu.
If you've been conducting a fourth level review, of service support review, which is how you described you were approaching this task, would you have looked only at data from within the branch?
Yes.
Not at any wider issues that have been identified elsewhere in other branches, for example, on that day or in that week?
No, because each branch was effectively operating independently. I mean, if it was a comms issue, that if there was some sort of central fault, so for example, the interface to the banks had gone down or something like that, then obviously that would affect many branches. But most issues really affected a specific branch at a specific time, and that was where I was coming from.
I think at all times you knew that Horizon had bugs, some of which would disclose themselves as they were occurring, but some of which might only be discovered long after the relevant event.
I felt that they would be visible at the time if you looked at the events associated with the thing in the branch. I think I later found out that there were some cases where it wasn't that obvious until later, but certainly if we look at where I was coming from in 2010, then my experience was that by looking at the events and the message logs from the branch at the time, then you would be able to detect if there had been a problem.
But I think more generally you knew that Horizon had bugs within it, some of which you would know about, but some of which may only be discovered a while after they had had an operative effect.
I'm not sure that that was the way I was looking at things back in 2010.
Do you look at things differently now then?
I'm aware that there were a couple of bugs with Horizon Online that did not manifest themselves immediately at the time that they occurred, but I'd not had that experience of similar sort of occurrences on Legacy Horizon.
So you thought your job was to provide an explanation as to whether something had gone wrong in a particular branch by looking narrowly at the data relating to that branch?
Yes.
If you concluded that the underlying cause of an issue was a bug in Horizon, would you have had any hesitation in saying so?
No.
If you believed that you didn't have sufficient information to arrive at a view, you needed additional information, would you have had any hesitation in saying so?
All I said was I could find no. What I was basically saying was I could see no sign of any problems. So I never said that there weren't any problems. All I was saying is that I had not seen any sign of any problems. So in effect, I was saying that that was the view that I was giving.
That's not really an answer to the question. If you believed that you didn't have sufficient information to arrive at a view and that you needed more information in order to do so, would you have had any hesitation in saying so?
I'm not very good at hypotheticals, so it's a case. I felt that I had enough information to say that there wasn't that I had been unable to see a problem.
So in every case in which you gave a witness statement or evidence, you thought that you had full and complete information upon which to say there were no problems with Horizon?
I wouldn't go that far. I made it clear in some of the cases with a generic witness statement that that was just at the generic level, and I was expecting to be asked to look at specifics, and as it turned out, I wasn't asked to look at specifics, so I was giving a general level statement of the general behaviour of Horizon, not the specific case of exactly what had happened in that branch. I was expecting to be asked to look at specific data, because my understanding was that in order to prosecute someone, then it was necessary to provide the data.
If it was your view that there was more than one explanation or possible explanation for an issue, and one of those issues involved there being a bug, error or defect, would you have had any hesitation in saying so?
I don't think so.
Did you understand that it was part of your duty to say that there are a range of possibilities here, and my assessment is this is the most likely or this is the least likely, for example?
I didn't understand that, no.
Thank you. Can we turn then to a separate topic, bugs, errors and defects?
Yep.
Can we start with some general questions, please? We've heard evidence, some evidence about bugs, errors or defects that Fujitsu believed could be lived with, i.e. did not believe disrupted the system to a material extent. And we've heard some evidence that bugs were not investigated for their root cause, including where bugs were caused by riposte and believed to be the responsibility of Isha. Were you aware of that?
I was aware that things had not been always thoroughly investigated, but I did not believe that such things had actually caused a direct impact on the branch accounts at the time.
What investigations did you carry out to satisfy yourself that the bug did not have an impact on branch accounts?
There were a number of cases in the early 2000s where there were unexpected events occurring, and in those cases I looked at what was actually happening. I mean, some of them were to do with the correspondence servers, others were to do with the branches, and in the cases I looked at, I couldn't see that there was, they're mainly happening out of hours, and therefore there wouldn't have been anyone doing anything at the branch at the time, and therefore I saw the thing as being benign.
Can we look, please, at FUJ 308 3596? And start with page 2, please. And if we scroll down. It's an email from you to Brian Orzell Can you remind us of who he was?
Brian Orzell was part of the EPOS development team, and he was the main interface between the EPOS team and Escher in terms of how the EPOS counter software operated.
You say, Brian, you've obviously cracked the technology to enable a list of pinnacles to be extracted to a file. How's it done? Alternatively, can you generate a list of the current Escher development pinnacles into a file for me, please? We need to go through an exercise of checking all outstanding pinnacles, at least the B's and C's. Is that a categorization of their severity?
Yes.
So as to factor them into, I don't know what this is, M1RS10 drops. What were they?
They were, I can't remember exactly where they were, but I mean, we're talking about 2000, 2001 sort of time scale in terms of when they were. There were a whole load of S releases that started with S10 and worked up to S16, S80, which we've talked about before in terms of impact and so on.
So they updates, effectively?
So they're updates, yes.
My belief is that many of them can be, quote, lived with, in which case they need to be downgraded to D or at the highest C, etc. If you knew that there were riposte issues that could only be explored fully by reproduction or by investigation by Escher, which you tell us about in your witness statement, how could you be confident that pinnacles of this kind could be lived with?
By looking at the effects that they had at the time and looking at the details of the individual pinnacles.
What do you mean by looking at the effects?
Looking at what the description of what had actually happened at the time, whatever was in the detail of the individual pinnacles.
Didn't that need, in order to be done to a satisfactory state, reproduction of the fault or investigation by Escher itself?
Not necessarily. It was a case of looking to see exactly what the problem was and what was behind it, to see whether it was something that what the impact of the problem was.
Can we go to page 1, please? He replies, as to the pinnacles themselves, I think it makes good sense to postpone them from last-minute fix releases. But given the amount of money we pay for support, when we have a full regression cycle, like presumably S10, I would want them all fixed, including the D priorities, no exceptions. Chris, I think that's Chris 1L, has the final say. So he appears to disagree with you and say that he wants them all fixed, but says the final call is for Chris 1L.
Yes.
What role did Chris 1L say?
He was the manager who had the managerial interface with Escher and did the negotiations with Escher. I'm not sure exactly what his exact role was.
Are you able to recall what happened with these bugs? Did in particular Fujitsu live with them, as you suggest, or were fixes found by Escher and applied?
I think some were lived with and some were fixed, but I can't remember which ones.
Were there simply some bugs then, even where the root cause was unknown, that Fujitsu and you were simply willing to live with?
It depended on exactly what the impact of it was, and that would have been done on a bug-by-bug evaluation, and this sounds like the start of a process where an investigation was done into the individual peaks and pinnacles to see exactly what the issue was, and I seem to remember there was a later email which identified at least one. There was an enhancement request, so it wasn't actually a bug as such. It was just something that it would be nice if the repose software did something differently.
So what was the outcome here?
That some things got fixed and some didn't, but I can't remember the details on the individual cases.
And the ones that didn't get fixed, was that without an investigation of the root cause?
There would have been an investigation as to what the symptoms were and whether that was something that was likely to cause harmful effects in the system. But exactly the details of such investigations, clearly I don't remember that at this stage.
In order to say that there were no harmful effects, didn't that require the bug to be reproducible by Escher?
Not in all cases, I don't think. in some cases, yes, it would need to be done, but in others, then it would be fairly clear from the description of it as to whether this was what the harm was that it was causing.
But it was the case that Mr. Orzell's suggestion that they all be fixed was not carried into effect.
I suspect not, but I can't actually remember all the details.
Thank you. Can we move on to 2005, please? FUJ 308 6315. FUJ 308 6315. Thank you. We're in August 2005. An email to you from Martin McConnell. Can you recall who Martin McConnell was?
He was one of the developers in the EPOS development team. He was actually
Sorry, I'm so sorry. It's from Mark Scardifield, copied to Martin McConnell to you.
Mark was the development manager in charge of the EPOS team at that time, and Martin McConnell was one of his developers.
It's about peak PC 0121925 and release S80, a shared stock unit cache declaration after, what does the rest of it mean? MIG greater than TP?
Is to do. I can't remember exactly what those terms meant, but one of the change with the introduction of impact, one of the changes was to actually migrate from branches producing a cash account each week to producing a trading period every month. So so the software had to be able to support both working the old way against the cash account, and then when some reference data was changed for a branch, it then started working in producing monthly trading periods.
So this is about, again, after S80 migration, is that right?
This was during the testing of the S80 software, so in other words, it's already gone live, and it was saying that the software on that particular test rig was configured that it was working in the branch trading mode as opposed to the cash account mode, is how I would...
Mr. Scardifield says, in summary, Martin can see evidence of two different types of failure. Firstly, a failure of message port to alert countercode when a new transaction has been inserted into message store. And secondly, a riposte query failing. My suspicion is that something, and I think we've now eliminated archiving because there's no trace in the event log, is hogging CPU time, and the riposte errors are a secondary effect. There's some evidence for this because at about the time of the second failure, BuzzyDoc.exe has logged an event, which it does where there is a sudden change in system resources. Needless to say, this problem or these problems cannot be reproduced at will. We've run out of ideas, so any thoughts appreciated. Is this an instance of a riposte problem arising which wasn't reproducible and which Fujitsu didn't understand?
This was a system issue, and I believe we decided in the end that there was some configuration had been set up incorrectly on that particular test rig, which was the cause of the underlying cause of the problem. We were unable to reproduce it. We did change some configuration parameters so as to make that if it were to reoccur, to make the effects make it much less likely to happen. But I don't think we ever found any evidence of that actually occurring in a live system.
Now, in relation to a separate issue, you tell us in your witness statement, your second witness statement, that the impact of the riposte log had been much wider than you had previously realised, and it was only by doing work in 2018, 2019 that you realised the full scope of the riposte log issue, and that you became aware it wasn't just a Calendar Square branch that had suffered from discrepancies, but other branches where there were counter occurrences of the timeout waiting for the lock problem, okay? I'm reading directly from your witness statement.
Yeah.
Okay. Would you accept that there may have been impacts arising from problems which weren't investigated at the time, but which may have been discovered with further contemporary investigation and support?
I think a lot of effort was put into investigating this particular problem, and it was not possible to reproduce the issue, and we did make some configuration changes to the way in which the software worked to protect against the fact that that the system performance could cause issues.
Can I turn, that can come down, thank you, to the first bug that I want to look at, data tree build failure.
Okay.
Can we start with some building blocks? This is more for my benefit than anyone's. In summary, a node is a unit of data structure that contains data. It's not a very good start.
Right. The data tree,
You're starting far too high up. I'm starting much lower down in a level of understanding. So a node contains data.
Yes, okay, yes.
And a data tree is a structure of nodes.
Yes.
It's a hierarchical structure of connected nodes.
Correct.
There is a root node which has child nodes to it.
Correct.
And each of which children can have further children.
Correct.
Each node can be connected to one or more child nodes.
Correct.
The root node has no parent.
Correct.
Aside from the root node, each node can only have one parent node.
Correct.
Legacy Horizon created summary accounts by building data trees and harvesting the information.
I'm not sure I've used the term harvesting in that case, but I think that's a reasonable word to use.
In Legacy Horizon, transaction data was stored as a message or messages in riposte.
Correct.
When Legacy Horizon generated reports or prepared accounts, it would scan the message store for relevant transactions.
Correct.
The relevant messages identified by Horizon would be stored in one of the nodes of the data tree.
One or more of the nodes of the data tree. There would be a number of different relevant nodes it would be stored under.
So the data tree in these circumstances was used to populate and to organise the data for Horizon to produce accounting reports.
Correct.
You say in your second witness statement, it's paragraph 36, no need to turn it up, that Legacy Horizon would reuse the data tree once it had been built with new messages being added. Is that right?
Correct.
And therefore, an example, would you agree, of a data tree build failure is where Legacy Horizon missed a node, such as a node containing payments in, resulting in the accounts being inaccurate?
There were different sort of errors at different times, and as time went on, more protection was put in to check against things like that. So I think
that would be an example. Sorry to
that was an example back in around 2000, and I think checks and balances were then put in place to detect such problems should they occur in the future.
Now, the inquiry is aware that Fujitsu came to know about data tree build failures, and that they could lead to discrepancies very early on in the life of Legacy Horizon. I think you know that there were such data tree build failures identified in Kells in 1999 and 2000.
I'm aware of that now. I think I only became aware of that when I looked at stuff in 2018.
Can we look, please, at FUJ 305 6677? Sorry, before we get that, I should just explore that last answer. How is it that you only became aware of the Kells and the Pinnacles of 1999 and 2000 when you came to look at it nearly 2 decades later?
Because I hadn't been involved in EPOS at that time, as we discussed this morning. So those were issues when I didn't have any responsibility or connection with EPOS in around the year 2000 or so. However, as part of the GLO, then I was asked to look at some of the peaks from that area, and in general, I relied on the information that the SSC came up with at that time, but as a side effect of that, I became aware that there had been those problems back in about the year 2000 that I was not aware of until that time.
When you became involved in data tree build failure issues in between those times, i.e. 99, 2000 versus 2018, 2019, did you not access Pinnacles and Kells?
Yes. I mean,
we're going to look at.
Yeah, I could have looked at the things at the time. It's just I had no reason to, which is why I wasn't aware of the problems until 2018 or so.
This is a Pinnacle PC 0033128, raised, I think, on the 10th of November 1999. Can we see that?
Yes.
The date that it's opened. Relating to losses, we can see on the left-hand side at branches in Dungannon. Can you see that?
I can see that, yes.
And I think if you read the body of the Pinnacle, outlet as a discrepancy, that's about 6 or 7 lines in, of £43,000 after balancing stock units and doing office snapshot. Steve Warwick, Development, is investigating why this misbalance occurred. Immediate impact of this week's balance has been addressed, but Post Office are concerned the cause is still unknown and this will affect this and other outlets. If we go over the page, please. 5 lines in, Steve Warwick believes this may be an isolated incident. And then about 5 lines further on, I'll monitor the progress of the incident, which is now with the EPOS development teams for investigation. 5 lines on, I've talked with development, referenced this problem. It is seen as a one-off, no fault can be found. And then over the page, 3 lines in, no further occurrences have been reported from Dungannon or similar. And then nothing on that page. Next page, please. Nothing on that page. Next page, please. Middle of the page, the problem's currently back with development for further investigation. Development, who would that refer to?
That would be the EPOS development team. So I think Steve Warwick's name was mentioned earlier, and he was the main designer and would almost certainly have been the person who would have been looking after this particular incident.
And then over the page. Just over halfway down, the similar current is currently an incident. I'm investigating if the similarities are such that we can add this into the problem. And then over the page, sorry, I should have read the bottom of that last page. Discuss this issue at XDMF. Is that some sort of conference?
I've no idea. I don't recognise that term. I'm guessing the MF stands for Management Forum, but I'm just speculating.
Some
I
sort
don't
of
recognise that name, yeah.
It's thought that a similar incident has, over the page, occurred at Yate Sodbury. So that's a different FAD code given there, so a different branch, to the value of £52,000. The problem will remain open. And then 4 lines on, a further occurrence has arisen at Appleby and Westmoreland. just under £10,000. Chase Call with Development spoke with Martin McConnell. He's made extensive investigations on the issue. He's been unable to recreate the fault. Escalated to Chris 1L Development, who'll discuss options with Martin and Steve. Foot of the page, a diagnostic fix is being prepared and was to be submitted to the next release management forum to authorise release into the live estate. And then if we carried on reading, I'm not going to carry on reading, it's reported that a fix was applied in 2000 by CI14.
Yes, I believe so.
In your statement, that can come down, thank you, you say that the effects of locking errors were more widespread when you were considering the calendar square bug. Yes?
Yes, but I'm not sure that was necessarily a locking error that was the root cause for that.
You say in your statement that that reflects the nature of fourth line support, where not every pinnacle on the same or a similar issue was referred back to the person who may have dealt with the same or similar issues previously.
Correct.
Was that just a function of the way that third line support was arranged?
Yes, but I mean, I suspect what you're saying is that this particular pinnacle refers to other occurrences, and I think the reason for that was because it was felt that they could provide additional information to help diagnose the problem.
When slow running issues became noticed in 2006, was any connection made between this series of issues that we've just looked at in this pinnacle and those slow running issues?
No, because I believe that the issues that were found back in 2000 had been resolved and sorted out at that time, and the issues that were occurring in 2006 was a different problem. It was to do with the fact that when we moved from a weekly cash account, then for a week's worth of transactions, you've got a certain amount of data. When you move to a monthly branch trading statement, then you've got 4 or 5 times as much transactions, and that's why performance again became an issue in 2005, because of the fact that there's just so much more data being processed in terms of producing the data tree as it was then operating.
Fujitsu's corporate statement to this inquiry splits the data tree build failures into 3 issues. Can I see whether what you're saying essentially mirrors that the classification is as follows? Firstly, issue 1 happened in 1999 and 2000 and was supposedly fixed as a result of the investigations that we've just read on that pinnacle.
That was my understanding, yes.
Secondly, issue 2, or 2.1, arose as a result of testing and didn't affect the live estate.
And I think that reflects the email you took me to sort of a few minutes ago, yes.
And then thirdly, issue 2.2 describes a single incident involving what is said by Fujitsu to be a transient discrepancy that was itself fixed in 2006.
I believe that was a separate problem introduced by some new software later on. I think in my witness statement, don't I describe those as 3 different issues? And I was disagreeing slightly with the way that the Fujitsu corporate statement was laying that issue out.
Let's look at your witness statement, his second witness statement, to the one ending in 0200, at page 11, please. Page 11. Page 30, paragraph 35. You say all 3 categories of this problem, that's the data tree build failure, concern the data server component in riposte, but I believe each problem was completely different from the other. The first category seems to have occurred in 99 to 2000, I do not believe I was aware of this first category at the time. Now, I've looked at the pinnacles for that first category, just for the transcript reference. I believe they are FUJ 306-2016, FUJ 306-6601, and FUJ 308-6553. And I can't see your name on any of them, and therefore I'm not going to ask you questions about them, okay?
Thank you, because I wouldn't know much about them.
The second category, you continue, occurred in 2005 to 2006. I believe I was aware of this second category at the time. So let's look at that, the second category of data tree build failure, by looking at peak PC 0121925, which is poll 302-8867. Look at the top of the page, you'll see it should be raised on the 13th of June. Yeah, if you just look under progress narrative.
Yep.
Date raised, call open, 13th of June 2005. And if we scroll down a little bit, Post Office have raised the incident as follows. Quote, a cash declaration was made in stock balancing for the amount displayed on the snapshot. When the cash variance was checked afterwards, again a £45 odd was displayed.
Can I clarify there, please, that when we're talking about Post Office has raised that, this was, if you look slightly above, it talks about E2E. So E2E was end-to-end testing. So this was a test rig, and this was Post Office testers on a test rig have identified this problem. This wasn't a problem from a live branch.
Got it. So is this Post Office staff embedded in the test rig?
Correct.
Okay.
So one of the stages of testing that was done was the Post Office staff would do their own independent testing of new software before it went live. So this is June 2005. So Impact S80 didn't actually go into the live estate until about August, September time.
And if we carry on reading over the page, please. I think we see, if we scroll on to the 4th of July, let's stop there, thank you. 4th of July, middle paragraph of Martin McConnell's third entry. If that could be highlighted, it's two-thirds of the way down the page. After spending more than a week on this, I don't know there's anything more that can be done, because the code is dependent on Isha's notify mechanism, which may itself beholden of perhaps some NT or other system failure. 2, we cannot reproduce this at will with any defined or prescribed pattern. 3, we can recommend a course of action to allow a clerk to get a fresh rebuild of the tree if he or she finds anything odd, simply by logging off and on again. The data server tree will automatically refresh. So what role did Martin McConnell perform?
He was one of the developers, and in fact he was the expert on the data tree build. You probably recognise his name from 2000. So
he is saying that he's not sure anything more can be done, and in any event, a solution is to turn the machine off and on again.
Yes, but I think we did actually do more than just that.
If we go forward to page 3, please. And if we scroll down, please. If we look at his entry at the foot of the page, I'm not going to read all of the technical explanation to start with, but just at the end of that paragraph, he's referring to a second occurrence of the fault, and he's saying this second occurrence is a different category and perhaps more disturbing, are not able to tell whether a silent feature has occurred within riposte, a failure has occurred within riposte and notified to us, or riposte is behaving okay, but EPOS has failed within the loop. So what was done?
I think we changed the configuration parameters to increase the buffering so that if the counter application was a bit slow in processing the messages that were being picked up, then there was a larger buffer of messages that could be buffered up to allow things to catch up. I'm probably not explaining that very well.
No, I think that's sufficient. More importantly, were you able to tell if the problems that had been identified in this test environment ever emerged and affected the live estate?
I don't believe we ever saw any sign of a problem like this on the live estate, and I think we did find some problems with the way that that particular test rig had been set up at the time.
Can we turn to your second witness statement at page 15, please? You say on page 15 at the foot of the page, at page 50, paragraph 51, I do not know whether the problems identified in the test environment ever emerged and affected live data in actual branches, or whether the fix rolled out for the second peak proved to be effective. In the absence of further documents, I can't say whether these problems had an actual impact on branch accounts. And was that the case at the time?
Yes, as I say, as part of the investigation into the problem that we were looking at before, the testers found another reproducible occurrence of the thing, and we found a genuine bug in the code that was then fixed. I think it was in August from memory, and that fix went in place where we found that the notification mechanism had been accidentally switched off in the code, and that problem did get fixed. And there was some further documentation about that.
You say, reflecting on the peaks now, with the benefit of hindsight, I believe there were probably other processes on the test rig counter that slowed down riposte and made it very unpredictable. And you say, as you mentioned in the test report, it is possible that these processes were caused by the testing environment and would not have occurred in actual branches.
That was my view, yes, at the time as well.
Was that hypothesis tested in the live environment?
I'm not aware of having seen any such issues happening in the live environment.
That's a different. That's an answer to a different question. Was what had been observed in the test environment tested in the live estate?
I'm not sure quite how you could test that in the live estate. So
actively looked for.
It would. Simple answer is I don't know.
Would failures in the data tree builds cause Legacy to produce inaccurate accounting reports?
It could do in the short term. However, if it missed a transaction one time, then there should be a corresponding failure the other way the next time the report was produced.
Should be or would be?
Certainly should be. I can't guarantee that it would be.
Would the failure to build the data tree have an effect on the accuracy of ARQ data?
No.
And why not?
Because the ARQ data was a record of the transactions as recorded in the message store, not how they were built up into a report.
Thank you. Can we turn to the third issue, or 2.2, as Fujitsu call it in their statement? That can come down from the screen. Thank you. I think that this is demonstrated through a peak. If we can look at FUJ 308 6456. Thank you. This should be peak PCO 132133. It is. And you can see that it's raised by looking in the narrative on the 10th of February 2006.
Yes.
And if we see the summary, postmaster states she has a discrepancy that seemed to, just read on a little, become greater over the course of 20 minutes. Then a few minutes later, the discrepancy vanished and normal figures remained normal. She noticed this on daily cash report previews referred by the MBSC. Discrepancy was at its highest £1,000 shortage, but postmaster insists within minutes the cash balance preview stated that the balance was fine and the discrepancy was gone. And if we go forwards, please, over the page. Thank you, just stop there and scroll down to David Seddon's entry at the foot of the page. He says he can see that on the 4th of February, the postmaster made numerous cash declarations on a stock unit. The postmaster was declaring all sorts of figures and getting different variations. What does stick out, though, is that the cash declaration done on counter 2, the postmaster declared £1,200 odd, and the system declared a negative value of £1,400 odd. Moments later, the postmaster logs on to counter 1 and declared £1,200 odd cash once again. This time, the system calculated a negative of £93 odd, which is roughly what the postmaster expected, even though no transactions have been done between these two declarations. Then skipping over a paragraph, it would appear that when working out the cash declarations on counter 2, the system has used an old data tree, the one it used at the earlier trial balance, rather than creating a new one, so the discrepancies were wrongly calculated. It wasn't until the postmaster later moved to counter 1 that a new data tree was produced and the discrepancies were calculated correctly. And if we can we summarise subsequently rather than reading it all? Is it right that a fix was developed and released later in 2006?
Correct, and I can't remember the exact why this problem introduced, but I believe that the data tree was actually being used for a new purpose as part of a change that was made at around that time. And as a result of this problem, then a different mechanism was used rather than reusing effectively a copy of the data tree. And I think that gets referred to later in this speak. So the whole bit of software that was actually calculating these cache levels was changed to not use the data tree anymore because of the problems that was identified in this peak.
Thank you. Can we look at an email concerning this problem? FUJ 308 6462. This is an email exchange involving Anne Chambers, Graham Welsh and John Burton. What did Graham Welsh do?
Graham Welsh was in customer services. I can't remember his exact role, but he was one of the people that used to liaise with Post Office, and he was a fairly senior manager at the time. And
John Burton?
He was a programme manager, and at that time he was probably my direct line manager. And
this exchange details problems in the scanning and building of the data tree during balance.
I think this is relating not to the problem we've just looked at, and this isn't looking at a bug as such. It was more to do with the fact that because branches had moved to the branch trading statement and therefore were building up 4 or 5 weeks worth of transactions, it was taking an awfully long time to actually produce reports. So it was, in huge branches, it was taking up to an hour to do that. And what Anne is reporting, the fact is that she was getting complaints from postmasters as to how long it was taking. Now, we had always made it clear to Post Office that one of the consequences of moving from a weekly cash account to a monthly branch trading statement meant that it would take longer to balance if you only balanced once a month. So it was something that we'd anticipated at the time. And as a result of this, I think I did do some further investigation to see was there anything we could do to improve the performance. And I think that's what this email exchange is to do with.
I see. Can we look from page 2 then, please? And scroll down, please. An email from Kimberly Yip to Graham Welsh and Dave Hulbert with the heading Horizon System Performance. Second paragraph, I've been contacted again by Post Office Service Line to obtain an update on the on progress on the current Horizon System performance issues. One particular branch has been escalated to me, and the last rollover timings have been sent to me by Anne Chambers at see below. From 5 o'clock, the branch started printing the daily reports, and this continued until 6:30. They then declared stamps and cash and pressed the balance report at 6:37. The trial balance was not printed until 9:12, i.e. over 2.5 hours later. Much of this time, the system was processing the month's transactions. There's a gap between about 7:30 and 8:05, where it may have been waiting for input from the postmaster, but I can't be certain. After the trial balance, the report was abandoned, presumably because the postmaster needed to check and resolve the discrepancies. At 9:27, cash and stamps were redeclared with some variation from the original, and at 9:28, the balance report button was pressed again. The second trial balance was printed at 10:58, i.e. 1.5 hours later, and the final balance at 11:04. I've looked at what was going on during the balance report production. There was nothing out of the ordinary apart from the very large number of transactions being processed, about 40,000. The number of transactions processed per second was rather less than we see sometimes, but not significantly so, apart from the period 7 o'clock to 7:10, when the counter end-of-day processes were running. Anne also provided me with some recommendations which I've passed on to the branch, and I will ask FS?
I assume Fujitsu services, but I'm not sure.
To do a similar exercise to the one above, i.e. provide timings when the next TP rollover is completed, 14th of June, to see if there are any significant improvements. I've been told about another branch, so I'm hoping to do a similar exercise. In both cases, the rollover times do seem excessive. My worry is these are not isolated incidents. In terms of the time it's taking branches to complete the balance process, this probably is Fujitsu provide me with details on what constitutes an acceptable length of time. For example, if it takes 4 hours, then this is reasonable, or if it's more than 5 hours, it needs investigating. This would then give me a better understanding of what I should be passing on to Fujitsu, or if I should be passing on the recommendations to implement. And if we scroll up, please. Anne, can you please comment? Scroll up. And scroll up again. Anne Chambers' reply, you're not copied in yet. I've looked at many branches now. They range from very slow to horrifically slow when rolling over stock units. It does vary depending on the particular processes followed at each branch. If you break it down into various components, each may appear to be just within 4 times as long as the weekly rollover used to be. But the impact on postmasters is horrible. There have been some piecemeal changes to try and improve certain areas, but most of these have made little improvement, and overall may have been a waste of effort. There are 2 main problems. One, the balancing process repeatedly scans and rebuilds the data tree. This was identified as a problem at least 6 months ago, and improvements to this are, I think, what Gareth is proposing. Counters are inadequate for the applications now being run on them, and do run generally slowly at times. This hasn't really been fully investigated and is really difficult to quantify or prove that it's happening. The only evidence is what the postmaster reports. However, it's adding to customer dissatisfaction and could get worse even if we improve balancing. I'm not at all happy about fobbing postmasters off and telling them that the system is working as designed when it is plainly inadequate for the job. I'm also very unhappy it's taken 6 months even to get to the point of starting to consider whether Post Office will pay for improvements. I too would like guidance on when second and third line support should investigate further. Our current response has to be, yes, we know balancing is very slow, it's being investigated. What else can we say. Was it the case that sub-postmasters were being fobbed off?
I have to take Anne's word for that. I didn't have direct contact with postmasters.
And being told that the system was working as designed, when in fact it was inadequate for the job at hand?
We had made it clear as part of the changes to impact that one of the consequences of moving from a 1 week cash account period to a 4 or 5 week branch trading period was that balancing would take a significant, i.e. 4 or 5 times as long, unless they did intermediate balancing in the weeks in between.
Would you agree with the view that she expresses here, that the system was inadequate for the job? Plainly inadequate for the job?
Clearly it was causing problems for the postmasters, but what we were responding to is what the Post Office had actually asked us to do, and we had warned them that there would be performance implications if they carried on, made the changes as had been proposed, and suggested that we could investigate improving the performance, but that would require additional costs to actually do that.
You say in your witness statement that you wouldn't view this category of problem as a recurrence of the first category of the data tree build failure that we saw. Is that right?
Correct. This was just things going slowly, not actually going wrong. They were just going very slowly, and clearly I can understand that postmasters weren't happy with that, but they were actually coming up with the right answer, but just very slowly.
So where it says in her numbered paragraph 1, the balancing process repeatedly scans and rebuilds the data tree, that's not connected to either the first, second or third categories of data tree build failure that we looked at earlier. Is that right?
Correct.
If we scroll up, please. You're included on this chain. Mr. Burton replies, I've reviewed Gareth's your feasibility report this morning and costings. Your report is based on a great deal of prototyping work that has been done over the last few months of the order of 100 man days. The work looked at a number of options and homed in on the one that gave best improvements. The report should go into Post Office next week. It'll then be up to them if they want to pay us to do the work. If they decide to go ahead, we're looking at a likely delivery date of first calendar quarter in 2007. That will give around 2 years of useful life before being overtaken by Horizon Online. I understand your frustration at having to deal with our postmasters and having to tell them the system is working to spec. We can only hope the Post Office do agree to funding this work, so you have something positive to say. Was anything done?
I honestly can't remember. Until I saw this email, I'd forgotten about that I'd even done some further investigations into it, and I don't believe the report has been made available to me to even know what I was suggesting.
On the third category of the data tree build failure,
Yep.
when you were, or indeed anyone else in development who was looking at that, was examining it, would you look into knowledge repositories within Fujitsu to see whether there had been similar problems in the past?
Not necessarily. I think we relied on the fact that people knew what had been looked at in the past.
Was there a system in place at Fujitsu that allowed technicians to ensure that when they were looking at a problem, they could investigate whether a related prior problem existed?
There probably wasn't a simple way of doing that. I can't remember one.
The inquiries heard evidence that the Pinnacle system and the Peak system that followed it, and indeed the KEL database, were searchable. Is that right?
Yes, they were searchable. I'm not sure I was very good at knowing how to search it. If I wanted to search for things, I would tend to talk to someone in the SSC, can you find information about this sort of thing?
So in 2006, if a technician had searched for data tree build or data tree build failure,
They probably could have found the peaks from 2000 if they'd applied the right sort of search criteria, yes.
and so they could have found evidence of earlier problems, allowing potentially a fuller picture
Yeah.
to have emerged.
Yes.
Was that kind of search ever done routinely by fourth line support?
I don't know is the simple answer.
Did you ever do that kind of search?
I don't think I would have needed to in the sort of fourth line support that I needed to do. It was something that maybe would have been done more by the actual developers rather than the designers.
You tell us as a final reflection in your second witness statement that, sorry, this can come down, thank you, that you are, quote, struck by the lack of support that was afforded to sub-postmasters when they got into difficulties, and that there would have been a real benefit in having a team whose function it was to have sight of all issues across the different levels of support, who could have drawn together the peaks and had oversight of what frontline support were fielding, and who understood the practical ramifications of issues upon those who worked in the branches and ensured that monitoring was working. Is that right?
That is how I see things now, looking back from 2023, 2024. It was not something that had occurred to me at the time. Perhaps it should have done, but it is certainly becoming very clear now from what I've seen, both with the GLO and with the work that's been done for the inquiry.
Fourth line support was really the final stage in the process on very difficult problems that couldn't be fixed by the earlier lines of support, correct?
Correct.
There went the problems that the SSC couldn't understand or didn't have the skill to remedy.
Not necessarily. If a code change was needed, it had to go to fourth line support because they were the only people who actually had access to changing the code. All third line support could do, and earlier lines of support could do, was actually identify avoidance actions or where people had been following incorrect process and that sort of thing. If there was actually a bug in the code that needed fixing, then it had to go to fourth line support.
For problems to get to fourth line support, they would have had to have got through the HSH or the MBSC and through to the SSC, is that right?
Only if they came from live, because a lot of faults were actually identified from test systems and things like that. And some things were identified internally. So there were a number of issues that were identified by SMC, who were effectively second line of support, that would then be able to raise them through to be investigated by third line support without involving the actual postmasters.
And just like it would be reasonable to expect that when you're investigating a current problem, you might search the peaks or the pinnacles or the KEL database for the existence of past problems of a similar kind. If you were giving evidence in court, you could use those facilities to search for issues or problems of a kind suggested by the sub-postmaster, couldn't you?
Yes, I guess I could have done.
But you didn't.
I didn't.
So it's just coming up to 4:30. That would be an appropriate moment to break. It's been a long day.
Yeah.
We're reconvening tomorrow at 10:05.
All right. I'll see you all tomorrow at 10:05. Mr. Jenkins, I'm sure you won't, but I should just tell you that it's not appropriate for you to discuss your evidence during the adjournments, all right? So that obviously applies with greater significance when you go home for the evening.
Yep.
Fine.
Thank you very much, sir.